Hello and welcome to the 14th episode of Business Litigation TV. This is the most passionate show you're going to find about business litigation. And today I want to talk about witnesses. The reason I want to talk about witnesses is I had a trial this week. Didn't go well. I lost. Now, I didn't lose because of anything I did or anything even my client did. I lost because of my witness. I put a witness on the stand who ended up torpedoing my case. Now, of course you're thinking, well, why did you put him on the stand? I put him on the stand because when it comes to a witness, I do a few things to ensure I'm going to get the best witness or best testimony possible. First thing I do is I just try and get the witness to come voluntarily to court. I don't want to have to subpoena him. I want him to be like, yeah, I'll be there and show up. Because I think that way, they're coming for my client and that they're most likely to give good testimony. So in this case, the witness showed up voluntarily. No subpoena necessary. He's like, yeah, I'll be there. I spoke to him a few days before the trial. I wanted to go over what he was willing to testify to, what he remembered. So I, didn't get any surprises, and I knew kind of where the limits of what to ask him were. And I always try and do that. Now, again, give very good testimony over the phone when I was speaking with him. And then I get him on the stand, and his answers had completely changed. Completely. I don't know why. Not about to speculate. Not going to put that out there. But I was shocked. My client was shocked. And there went our entire case. And there's nothing I can do about it. Unfortunately, I didn't have any previous statements by the witness, that I could work with. And again, I feel so bad for my client. Because, as I said, I do everything I can to make sure I know what a witness is going to say. And the fact that I put a witness on the stand who said the exact opposite of what I thought he was going to say was flabbergasting. But that just goes to show you never know what you're going to get when you take a case to trial. A lot of people want to take a case all the way to trial because they're like, I'm not settling. I want everything that's owed to me. That's all good and well, but what happens when you have a case like mine? My client wanted everything that was due to him, and I don't blame him. But when the witness torpedoed it, luckily we settled for a small amount, but he could have gotten nothing. Nothing. And you run that risk every time you go to trial. Not that a witness is going to torpedo your case, but that you may end up with nothing. So when it comes to, like I said, when it comes to a case, you definitely want to always look at settlement. Because if you can get something good, or at least a lot of what you're asking for without running the risk of trial, then you may want to take it. Of course, every case is different. I don't always recommend settling, but it's something you always have to take into consideration because something is better than nothing. That's one of my favorite mottos. Something's better than nothing. And I hate when my clients walk away with nothing. So, if you have any questions for me, you want to know how you can walk away with something rather than nothing, or you just want to discuss how to prevent a situation like this one, or any litigation, please email me at jesse@jdelaw.nyc. That's jesse@jdelaw.nyc. Until next time, take care.